Sorry, 12 minutes, 30 seconds with regard to the 14th Amendment.
Good afternoon, and may it please the Court. My name is Isaac Harris on behalf of the State of Olympus, the respondent in this matter. Your Honor, the Court should affirm the ruling of the Court of Appeals that the Health and Effective Action Law, henceforth known as HEAL, does not impose an undue burden on Petitioner Cassandra Williams. The State was well within its rights and in fact was fulfilling its obligation when it called for Petitioner's child, WB, to receive the treatment stipulated in HEAL. This is a proper exercise of the State's rights for two reasons. First, the State may intervene in a field relationship over the objections of a parent in order to protect the health and well-being of a child. In this case, the State's actions safeguarded WB from a dangerous and potentially life-threatening disease. The State also, through the legislature, may enact laws to protect the health and well-being of all citizens. That is the second reason why this was a proper exercise of the State rights. The State is uniquely endowed with the duty to preserve the health of the citizenry, and legislation that advances this interest by containing the spread of contagious and infectious diseases such as leukemia are proper actions by the State. HEAL is thus justified on both counts. Would the Court like a recitation of the facts? So I would begin by refuting briefly the arguments brought up by the 14th Amendment counselor on Petitioner, and then move into the State's own arguments. So from Petitioner, we hear three arguments as to why it poses an undue burden on Cassandra Williams. The first is that it violates her parental liberty interests, and they use the clear and convincing evidence standard, citing Newmark. However, Newmark also goes on to say very clearly that parental rights are not absolute in any way whatsoever. And in fact, the court in Newmark says, quote, that a parent may not make martyrs of their children, end quote. So reluctancy to infringe upon a parent's privacy rights, no matter how fundamental they may be, does not make it as such that the State may not intervene over a parent's objections in order to protect a child being made a martyr of as a result of the parent asserting their privacy rights. The mere fact that there is a liberty interest at hand, the parental liberty interest, does not make the statute unlawful, and I will begin to touch on that in my second point.
So it seems though that Newmark dealt with a pretty severe case. I mean, he needed chemotherapy, the child had a form of cancer, and instead the parents want to take him to a Christian Science practitioner to get some kind of like religious assessment. And that seems to me even more of an issue than in the case of Barr, where the mind-body treatment process may well be effective. What is to keep us from saying that the mind-body treatment process isn't effective? That doesn't seem supported by any medical professionals.
Well, Your Honor, Jacobson v. Massachusetts holds that it's not the role of the court to decide what treatment is effective, and it's the role of the legislature. And in fact, quoting from Jacobson, it says that, quote, that was for the legislative department to determine in the light of all the information it had or could obtain, that being the mode which was most likely to protect the public against disease. So that's moving into the second facet of the State's argument, which is that the State was acting to protect the health and public of all of society, not just WB. But in any instance, Jacobson holds that it's not the role of the court to decide which mode of treatment is most efficacious, but instead the role of the legislature. So moving back into refutation very quickly, the petitioner's second argument is that the State does not meet the heavy burden, and they base this on the notion that there are alternative steps that may be taken instead of quarantine, talking about this alternative test as determining which somatic region it affects and which developmental phase it's in. But if you look closely at Appendix B in the record, Your Honor, it never actually says that there is any sort of internal test. Petitioner assumes that it's implied when Appendix B says that, quote, the developmental phase and somatic region of leukemia cannot be determined by external symptoms, end quote. So in fact, there's no evidence of the record that any sort of internal test does actually exist. And so for Petitioner to base their argument that there are alternative steps based on an internal test...
Maybe there is no... We don't know whether there's an internal test, but the idea is that there wasn't enough done to make sure the diagnosis was correct. And how do you argue against that idea that maybe HEAL could have done more, maybe by taking the pretty reasonable step of at least ensuring that the people making these diagnoses have specialized training to do so?
Well, Your Honor, once again, you have to go back to Jacobson and say that it's not the role of the court to second-guess the legislature's decision-making when it regards to legislation that clearly affects has some reasonable competency within the relation of the state to protect the health of society in this instance. So Jacobson makes very, very clear that the legislature, you have to trust, as society, that the legislature will take everything into account and make a decision that will act in the best interest of both the child in question, or the individual in question, and also the health and well-being of all of society.
But even Jacobson said that if it's an arbitrary or unreasonable law, then you can strike it down. So is this not an arbitrary and unreasonable law?
Well, yes, Your Honor, you're correct. That is the test from Jacobson, but the HEAL easily passes the test from Jacobson. It is not arbitrary, nor is it unreasonable. So it is entirely reasonable to say that it will protect the public health and the public safety. because protecting the public health and the safety are the essence of government. And the court in Jacobson notes that upon the principle of self-defense, it is a paramount necessity that a community has the right to protect itself against an epidemic of disease which threatens the safety of its members. And it's reasonable for the state, through the legislature, to enact legislation that furthers that interest, the protection of self-defense. It's a paramount necessity that the state has the ability to do so. So no, it's not unreasonable. The HEAL is not an unreasonable or arbitrary law.
So what, 30 days seems arbitrary to me, though. I mean, why a 30-day quarantine? There seems to be no founding for that.
Well, Your Honor, the Department of Health officially recommends a 15-day antibiotic treatment, and that presumably addresses an average instance of leukemia that takes 15 days to treat. In the legislature, the State of Olympus legislature, in passing HEAL, has instead extended that to 30 days in order to address any instances where leukemia may stretch beyond 15 days so that they're not being exposed to the public and they're not exposing, imperiling the health and well-being of the public through contagion, because
that's exactly the issue. I mean, why double it? I mean, the Department of Health, the composition of a qualified doctor said 15 is enough. I mean, why double it, especially since he wasn't under advisement by medical practitioners, and it was written without their advice. I mean, it seems that that's the height of an arbitrary decision.
Well, Your Honor, once again, I hate to beat a dead horse, but you have to go back to Jacobson, and you have to go back to the language that says the legislature has the authority, and in fact is compelled to act in paramount necessity in order along the ideal of the protection of self-defense in order to enact laws that reasonably protect the health and safety of the public. So if it is reasonable that it will protect the health and safety of the public, and it's not arbitrary because it only affects people definitively diagnosed with the disease that has the potential to be contagious, then it's well within the state's rights, and is certainly a lawful exercise of the state's rights to do so in order to protect society and the health and well-being of society.
So Jacobson didn't have an alternative, right? So when we're looking at the Jacobson standard, in the case of Jacobson, the patient didn't want to receive treatment, but he also didn't advocate alternative treatment. In Newmark, there was an alternative form of treatment, and that was going to the Christian Science practitioner, and it was a different standard. So in the case at bar, we also see that. It's not just that WB doesn't want treatment. He's willing to have treatment, but he wants to have treatment through the mind-body process and not through this official state. So does that not shift the burden of proof in favor of petitioner to show that you need to prove that the mind-body process by clear and convincing evidence is ineffective?
Well, Your Honor, you're getting into the discussion of which test we should apply, which is the third argument of petitioner, whether it's the Newmark test or the Jacobson test. So first, the petitioner says that there's no liberty interest at play in Jacobson. Of course there's a liberty interest, the interest of Mr. Jacobson to not be vaccinated. And the court in that case held, so what that he has a liberty interest? The state must be able to protect the health of all individuals and not subordinate the needs of the many to the need of Mr. Jacobson that he doesn't want to be vaccinated. The second reason that we should apply the Jacobson test and not the Newmark test is that Jacobson comes out of the Supreme Court and Newmark comes out of the Delaware State Supreme Court, so therefore it's more controlling. But beyond just that, looking at actually the merits of the case, even though, despite the fact that leukemia may not be an epidemic at the level of smallpox in Jacobson, petitioner themselves have admitted that it is contagious. And so that's why Jacobson is dealing with contagious diseases and Newmark is dealing with leukemia, which is of course not contagious. So that's why we need to look at Jacobson and not the test from Newmark. Instead, this court should apply the test from Jacobson. So, Your Honor, we could never have a functioning society, the court tells us in Jacobson, if everyone was allowed to make only private decisions based on their own welfare without the public good ever being considered. The court tells us that real liberty could never exist if each individual was allowed to apply the laws to him or herself without consideration of the public good. And again in Jacobson, the court describes how we are unwilling to hold it to be an element of the liberty secured by the Constitution of the United States that one person may have the power to dominate the majority when their action is supported in their action by the authority of the state. So when the majority is supported by the authority of the state, as the case we have here, the majority of people are healthy, are not infected with leukemia, and do not wish to be imperiled by being exposed to WB, who has the contagious strain of leukemia, when their actions and their needs, and chiefly the need to stay healthy and to protect their health and well-being, when the state and the legislature act in order to further advance those means and protect that interest, then the state intervention is lawful, regardless of the fact that there is a liberty interest that is at play. So the holding in Jacobson recognizes that the police power of the state includes the power to enact reasonable legislative regulations whose intent is to protect the public health and safety. So then moving into the other argument of the state, which is that it's appropriate for the state to compel Ms. Williams to treat her son for this life-threatening disease in order to protect the health and the well-being of WB. This was the first argument, but as we have discussed at length, the second argument, I'm going to shift back into the first one. So the case law is replete with examples of courts stepping between a parent and a child to take measures to protect the child when the parent neglects to take the appropriate steps. And that's what we have here. WB's hairline is receding, he has a fever nearing 102 degrees, he's coughing significantly, and Ms. Williams was not pursuing a medical treatment that was recommended by anybody other than Dr. Ho, who's not even an infectious disease specialist.
But what if that was just like the common flu? Did it necessarily have to be La Quinta? I mean, Appendix B says that those very same symptoms don't necessarily imply that you have a La Quinta strand. And even if you do have a La Quinta strand, it's 97% likely that it's not contagious.
Well, Your Honor, with regards to WB, there is still the chance that it's fatal and life-threatening. And so when Dr. Ho, a state-licensed medical practitioner, diagnoses WB with La Quinta, therefore the state is now asserting its interest in protecting the health and well-being of WB.
Sure, but why not more tests? Why not try to ensure that maybe you need a special? It seems too broad. It seems to just, based on an initial assessment by someone not specialized to identify infectious diseases, a child is going to be placed in a quarantine for double the period of recommended time by medical professionals and imposed to an intense antibiotic regimen before there's any determination that he actually has a contagious disease. In fact, against the odds, the overwhelming odds that he has a contagious disease.
Well, Your Honor, Pierce v. Society of Sisters, the 1928 Supreme Court case, outlines when the state interference is lawful. So that's the test as to when the state may intervene to assert this interest. And in Pierce, the court rules that rights guaranteed by the Constitution may be abridged only by legislation that, one, has reasonable relation to the purpose within the competency of the state, and two, is not arbitrary or unreasonable. So with regards to the first prong, he has an obvious relationship, again, to the purpose within the competency of the state, both to protect the health of WB, as acknowledged in Newmark, and in custody of a minor, which says that the state may intervene in order to protect the child. So that's the first interest that the state has that's within the competency of it, but also to protect the health and well-being of society. And then again, HEAL is not arbitrary as it affects only citizens who are definitively diagnosed with a life-threatening disease. Nor is it unreasonable for the state to take steps to protect the health of its citizens. And in fact, in custody of a minor, it says that the state has the unique duty to take steps to protect the health and well-being of its citizens, whether it's simply the child at play or the health of all of society.
So I'm getting that there's an important standard. I'm getting that it's important to protect society. I'm getting that it's important to place people in quarantine to prevent them from spreading the contagious disease to society. If that's so true, and if this need to protect society is so great, why allow people, after being diagnosed with this potentially fatal, contagious, dangerous disease, as you're portraying it, why allow them to roam the streets freely for 10 days before they're even placed in quarantine?
Well, Your Honor, I see my time's up. May I briefly answer and conclude? Okay, so with regards to the 10 days question, Jacobson teaches us, again, that we should not second-guess the legislature in these matters. Any statute could be scrutinized or could be criticized, but there's a better way to address the problem. If the statute mandated reporting within 2 hours, people would complain that it was too burdensome. And the petitioner likely would not claim that there was any less of a burden placed on them if they were given only 2 days to report. Right? So as Jacobson says, we must presume that the legislature took into account all of these competing opinions, tried to balance those concerns in writing the statute, and it's not the function of the court to second-guess the legislature. Also, the 10 days is simply the maximum amount of time given to the individual to report. Dr. Ho, at the time of diagnosis, told Ms. Williams and her son that, look, this is what the state wants you to do, and you should go into quarantine right away, and these antibiotic treatments, some members of the medical community think will be efficacious. So that's simply the maximum amount of time allowed, not what we would reasonably recommend by doctors. So in conclusion, Your Honor, the state was well within its rights when it called for petitioner's child WB to receive the treatment stipulated in HEAL, and thus the court should affirm the decision of the 14th Circuit, as HEAL does not pose an undue burden on petitioner Cassandra Williams. Thank you.